Good evening. It's Norma Kirkby, Program Director at the Alzheimer Society of Manitoba, hosting What Matters Most this evening. Tonight we have with us Heather Ann Dixon, who is a lawyer here in Winnipeg. She works with the People's Corner law firm in Winnipeg. Heather has been a longtime friend of the Alzheimer Society of Manitoba. And Heather, we welcome you tonight to talk about legal aspects that family members of people with dementia need to know. I turn it over to you. And through the evening, if our participants have questions, you may place them in the message box, and we will check on those questions and answer them periodically throughout the evening. Heather, it's up to you.
Well, thank you, Norma. I'm very pleased to be here and to maybe help shed some light on the legal documents that everybody should have, but that it's particularly important when there is a person who has dementia or any other debilitating disease, that they can't manage things on their own. I'm going to do a lot of this through a Manitoba perspective, but I will talk to you about other jurisdictions as well through the conversation. But let's start out with our first slide and move on. And if you have questions, as I said, I'll be happy to answer them. This does not seem to be working. I'm not getting. Yeah. There we go. Okay.
You've gone one more than you want.
Okay. Most people come into my office, and what they say to me is, "We need a will," and they'll say, "I need a will. My husband's ill, or my wife is ill, and we haven't got our wills, and we've got to do them. And can you help us with a will?" And I am really happy to do that. I'm very happy to do it, particularly when families are together and healthy and happy, because you can only make a will when you are still competent. And one of the saddest things for me is when I have to say to people, I don't believe this person has the legal capacity to make a will. But I'm going to talk to you as though you're still in this situation where if you have a spouse, both of you are still competent and capable of making wills and powers of attorney, etc. And a will is important. I mean, it's an important part of a good estate plan. It does save you money. It saves taxes. It can save a lot of time after death. And when you have a situation such as underage children who have a disability, or someone else who relies on you for a disability, it can allow you to set up a trust for that person so that they don't lose their benefits, but they continue to receive the benefits, but they still can receive under your will. And you get to determine who gets what and when and how. And that's all great, but you can only determine who gets what and how and when if there's any stuff left over. And part of the biggest problem is that people do not prepare properly, and therefore when they get their get to the probate process, suddenly there's nothing left. So I'm going to talk about how to prevent that situation, and that situation comes about before death, obviously, because if you have no assets at death, you had them before. And I tell my clients they need to think about two things besides what's going to happen to their stuff after death. What if you become ill and can't manage your own affairs? And when I say ill, you can have physical disabilities, cognitive disabilities, any type of disability. What if you can't manage your own affairs? And what is going to happen to your stuff if you can't handle it? So I want people to think about illness as a real possibility as you age, and I want them to think about their stuff. So think about you, think about your stuff. I've done this little drawing for people. As you can see, I've done stuff and you across the top. And down the left-hand side, that's before death and after death. And as I said, people think about their will a lot. And sometimes they think about their funeral. But what a lot of people don't understand is it's that the executor of your will is the person who has control over your funeral. And that's a very important thing to know, particularly if you are leaving underage children and you've left your funeral in the hands of your next door neighbor, your best friend, what have you. So you want to make sure they understand what you want after your death. But it's those two documents before death that are really, I'm going to focus on mostly tonight. And that is your healthcare directive and your power of attorney. Now, to make matters more confusing, I mean, it's not like we make things simple when we're dealing with law. In Manitoba, we have different names for these people, okay? The power of attorney, the person who has the power that you give them, the power of attorney is the document itself. The person who has the power is the attorney. And we always say, do you have a POA? And meaning the person, but it's really just an attorney. A healthcare director, a healthcare person who is assigned your healthcare abilities is your proxy in Manitoba. Now, I went through other provinces. Some of them call them agent, some of them call them substitute decision makers, some of them call them attorneys for personal care, all sorts of names. But your healthcare directive and your attorney are your proxy and your attorney are two different people, two different things. Now, they may be the same person, but they have two different hats. They are doing two different things. Your executor and trustee, you might have the same person for all three documents. That's allowed. But what you really, really want is to make sure that you understand the difference in the functions and the difference in the documents. Now, call me foolish, but I think the most important thing, what really matters, is the person. And so the healthcare directive is probably the most important document. It's the document that says what people can do or what doctors can or should or might do with you. And it's the person who gets to make the decisions for you if you can't make those decisions yourself. Now, here's a little bit of boasting. Manitoba has had a healthcare directive since 1992. We were the first jurisdiction in Canada. And in Manitoba and across Canada, whatever your healthcare directive is called, we know it's underutilized. Now, just to give you an idea, in Yukon, it's called an advance directive. So if you're from the Yukon, you'll know what I'm talking about. In Northwest Territories, it's called the personal directive. In BC, it's called the advanced healthcare directive. So we're getting close. In Saskatchewan, it's the healthcare directive, but they also use the term living will. Now, Canada doesn't recognize living wills. It's a concept brought up from the States, but I think they've done that and put it into their legislation in order to make it easier for people to understand what a healthcare directive is, because some people have been using a living will for years in Canada. In Manitoba, healthcare directive. In Ontario, it's called a power of attorney for personal care. In Quebec, it's called a mandate. In New Brunswick, a power of attorney for personal care, same as Ontario. In Nova Scotia, it's called a personal directive, same as Northwest Territories. In PEI, it's called a healthcare directive. There it goes again. And in Newfoundland, it's called an advanced healthcare directive. In Nunavut, they don't have any legislation. So you can see that the healthcare directive is a provincial matter. What you need to do when you go to your lawyer is say, I want a healthcare directive that appoints someone else to make decisions for me if I can't make them myself. Now, a healthcare directive can be simple or complex. It can be lawyer-made or a pre-printed form, or in some jurisdictions, it can be written by hand. The most important part of the healthcare directive, though, is naming of a proxy, the person to make those decisions for you. In some jurisdictions, this proxy is called an agent or an attorney. It is a person or persons who can make decisions for you regarding your health or medical treatments. If and only if you cannot make them for yourself. No doctor is going to approach the bed with the patient lying there, perfectly competent and able to make their own decisions, and say, I need to talk to your proxy. You just ignore it. You just lie there, and your proxy and I will talk about what we're going to do. Of course, if you are not competent, then the doctor might want to talk to the proxy. But every doctor I know has tried to include the patient in the decision. Now, here's what's really important about your proxy. If you appoint someone as your proxy, then you have to have a really serious discussion with that person. What do you want? What do you need? And you need to think about end-of-life issues. Now, the discussion is your responsibility, but lots of jurisdictions have guidelines for people as to how to have the discussion, and even your doctor will help you get to the point that you know what issues need to be discussed. And right down to pulling of the plug. A proxy cannot override you if you are still competent. But a proxy can instruct a doctor or other medical provider who doesn't want to do something to do it if the proxy knows that's what you want. And any decision that a proxy makes has to be an informed choice. And therefore, your proxy has to be able to speak to your medical provider. And one of the things I have noticed on forms, pre-printed forms, is that they very rarely refer to the fact that the proxy can have access to your medical records at all times. So if you're thinking about running to your lawyer tomorrow to have a healthcare directive drawn up, make sure that is included. It doesn't matter what jurisdiction you're in. Doctors cannot do any service to a human being without there being informed consent. In order to be informed about what you're consenting to, you have to understand the nature of the treatment proposed, the benefits of such treatment, the risks of such treatment, and any alternative treatments. You can't do that. You can't make those decisions ahead of time because you don't know what you're going to have later on down the road. I have a lot of clients that come into me and they say, I want this if that happens, and that if this happens, but not that if this and that happens, and not this if that and this happens, but only if it doesn't happen this way. And I keep thinking, why are they trying to do that? To me, it's better if you have a proxy that you have appointed who knows your life, your values, your wishes, your wants, and you just leave the treatment to them. Because they're the ones who are going to be able to talk to the doctors at the time the treatment is happening, not while you're trying to write up a treatment plan. It doesn't matter if it's an advanced care plan or a healthcare directive or a personal directive or power of attorney over a person. The person making decisions must be informed to make a proper decision. If I were perfectly healthy and going into the doctor today, the doctor would have to tell me absolutely everything that they want to do. And if they don't, I can sue them. You can ask friends of mine who practice medical malpractice. Now, the advantages of a pre-printed form, like the one we have in Manitoba, is they're usually very simple. Many of them, no witnesses required at all. They are available because they're online, and I checked last night, and there's one for every jurisdiction in Canada. They're easy to change because you don't require a witness, and it's great. And if you haven't got access to anything else, at least get one of those forms. But remember, the proxy is the important. If you're going to make up your own, let me recommend you don't use legalese. Just use plain English. I recommend you appoint only one proxy at a time. A lot of my clients say, oh, but my son will be so hurt if I appoint my daughter, or my daughter will be so hurt if I appoint my two boys. One at a time, please. It's a good idea to have alternates, but one at a time means that one person is talking to the doctor. I had one client who came to me. They came to me as an estate, not as for a power of attorney or a healthcare directive. And the son told me that the mother had named all 6 children as her attorneys jointly, which meant all 6 had to agree. And apparently they didn't agree on anything. And when it came to making healthcare decisions, the same thing happened. 2 of them wanted mom to go into personal care. 1 of them wanted mom to go and live with them. Another one wanted mom to go into an apartment and hire full-time nurses. It was a mess. I always recommend one proxy at a time. Keep your proxy information up to date. The form in Manitoba has name, address, phone number of the proxy, and that's so your doctor can get in touch with them if something urgent should happen. And if you don't keep that information up to date, how are they going to contact you if this happens to be an urgent situation? How are they going to contact the proxy, if it's an urgent situation? For instance, you can include email, you can include text, you can include mobile phone. Somebody said to me once, should I put their mobile down too? Yes! They traveled throughout Manitoba. They were never home. I mean, it would have been a disaster. As much contact information as possible. And if your proxy moves around, then make sure that's on your form, that you keep it up to date so that people can contact your proxy right away. Now, unlike the will, which we advise our clients to put into a safe place, if our client wants to take the will home with them, put it into a safety deposit box, put it into a steel box at home. I tell my clients, give a copy of your healthcare directive immediately to your proxy, or however many proxies or alternates you've named. And that's so they can have it quickly to show someone. yes, they are the right person. Give a copy of your healthcare directive to your doctor or doctors. Give a copy to each person in your family. Keep a copy of the healthcare directive with you. Keep a copy in your car, in your glove compartment. I mean, so many people get into accidents and they're saying, is there a healthcare directive? If it's in your car, they'll find it real fast. They're looking for your ID right away. They can find your healthcare directive if it's in your wallet. I had one client who laminated it, shrank it and laminated it, and attached it to his health card. So he knew if he had to be taken to a hospital, they were going to find it because they were going to find his health card and identification. I don't recommend DNR. And the reason I don't recommend DNR is for the very reason of informed consent. You don't know when you are going to need resuscitation or under what circumstances. For instance, we have a great time doing this, Norma and I, and afterwards we go out for coffee. Norma's made a healthcare directive and she put DNR on hers. Norma starts choking on her muffin. Does she want me to intervene? Does she want me to call the paramedics? Should they be resuscitating her? You'd say, of course, that's common sense. But that's not what the form said. So I don't recommend it. But if you want to take your chances, by all means, go ahead. If you have complex instructions, in spite of what I've said, you want to put down complex instructions, then seek medical advice before you do it. Not legal advice, medical advice. Because we don't have MD after our names. Some of us had JD and some of us have LLB. It just means we're in law, not medicine. Even complex instructions can be overridden if there is no informed consent. So I just don't see the problem. I just don't see the purpose of it. Now, that's the healthcare directive. And everybody over 16 in Manitoba is entitled to have one. In other jurisdictions, it might be 18, it might be 19. As far as I'm concerned, if you don't have one, you're missing out big time. The number one most important document. Now, the second most important document that you should have in your arsenal is the power of attorney. And I say second, and it's a distant second. The first one's about you, your health, your body, your life. How important is that? We're now talking about a power of attorney that deals with your stuff. And I know, these are your assets. You've worked hard and you have certain people you want them to go to, and you are very proud of what you've accumulated. But it's still stuff. Your money, your car, your house, your clothing, your jewelry. It's stuff. I still think the person is more important. But we're on to stuff now. Power of attorney is a document that deals with your stuff before death. You have to be competent when you make it. You have to have legal capacity. And the biggest consideration when you're choosing someone to be your attorney is, do you trust them? Can you trust them? Are they trustworthy? And the next consideration is ability. And the reason I say that is that if the person is trustworthy, then there will be records and there will be a paper trail. So you can always figure out what happened. The power of attorney document is a document that gives power to another person, gives the power to another person to deal with your property, but they don't own it. You still own it. All actions taken by the attorney have to be in your best interest. One of the saddest things I see with a lot of people is they don't understand that the attorney doesn't have to have their name on your bank account. You don't need that. The attorney is allowed to write checks on your bank account if they have a properly signed document. They don't need to put their name on it, because when you die, the bank says, the attorney's left on the account. It's all theirs now. And we've had cases in Canada that have said, when you leave to one child, everything, they've got to share it anyway. And you might think, yep, my kids would. Would your in-laws share it too? Think about that for a minute. What if your child died and left, one of your children died and left a spouse, and one of your other children is the attorney? Would your child share with that ex-spouse? Gotta think about this. Think about it carefully, because it can lead to very expensive lawsuits. But I do not recommend putting joint names on anything. The attorney doesn't need it. People say to me, yeah, but I've heard bad things about powers of attorney, so I'm only going to make it when I absolutely have to. Yeah, I understand that. But there are ways you can avoid abuse. Some of them stronger than others. One of the best ways is within the document itself to instruct the attorney that they have to report to someone at a regular interval, 6 months, a year, whatever. That they have to give reports to this person, and if this person is not satisfied, this person is entitled to go to court. You can do that without offending your children. If you've named one child your attorney, then for heaven's sake, why can't they report to your other 3 children? It's really a very simple thing. And they can do it any way they want, whether it's just by showing the bank accounts, whether it's by showing the checkbook, whether it's by showing the bank accounts, the checkbook, and the investment sheets, whatever you want. But there should be someone that they report to. If you make your wishes known well in advance, too, then your kids will be expecting who will be in charge. And it won't be a big shock when somebody says, well, Mary is mom's attorney. And they all say, why Mary? And why isn't it me? And that's where a lot of distrust and anger comes in, because they all think Mary tried to pull the wool over Mom's eyes, and Mom was unwittingly helping her to accomplish this, when it could have been Mom all along. You need to have a frank discussion with the whole family and tell them, I've chosen Mary because she lives closest to me, because she takes me to the hospital when I need to go, or to my doctor, because she takes me to the bank and the bank knows her. I tell my clients, when they've made their powers of attorney, when they've got the document in hand, take your attorney to the bank and introduce them to your banker. The more you do up front and ahead of time, the less chance there is of arguments and dissension after. I'm not able to, oh, okay, sorry. Okay. Now, I have to mention something in Manitoba, specific to Manitoba, in case there are Manitobans out there. Our Power of Attorney Act is overridden by our Homestead Act in Manitoba. And the spouse, as attorney, cannot sell the family marital home, even though they are attorney for their other spouse. So husband is attorney for wife, wife is in personal care, wife is not competent. Husband cannot sell that house unless when the power of attorney document has been made, when it is executed, there is a homestead release and acknowledgement attached to it, and there is someone else appointed to sign on behalf of the incompetent spouse. You may have similar laws in your jurisdiction. You have to go to your lawyer and say, is there anything my attorney cannot do by our law? And you should also reference your homestead release and acknowledgement in the affidavit of execution. But that's what lawyers know. I've put that in for another purpose here.
Heather, there is
Yes.
a question that has come in, and maybe
Okay.
we will include it now because you are talking about the importance of a spouse's attorney not being able to sell marital property. The person is asking, should a spouse be a power of attorney for someone who does have dementia?
There is no reason why a spouse cannot be power of attorney. You can name one of your children. I've seen that, but it's often in a situation where there is a second marriage, and that leads to a lot of problems. Very often the public guardian and trustee will get involved because it turns out that, you know, the at-home spouse's property is not being recognized, and the in-care spouse, the attorney has become rather aggressive and is taking more money and moving it around. It can lead to a lot of problems, but there's no reason why a spouse cannot be an attorney for another spouse. Of course, you might not want to do that if you're in a second marriage situation. But these are things that you need to discuss with your lawyer. You know, why would you want to not name your spouse? Sometimes you might think my spouse is ill. My spouse is not going to be capable if I'm not capable. Well, that's not always true. And even when I name spouses as each other's attorney, I always name an alternate, so that if something happens, and the alternate, and I name the circumstances in which the alternate can step in. If my spouse has predeceased me, if my spouse is ill and unable to, then I need a letter from a doctor saying he cannot. If my spouse doesn't want to, then I want a letter to renounce the right to be my attorney, and then my alternate can take over. Now, the thing about powers of attorney in Manitoba is an alternate cannot take over if the other person has already started acting, unless the other person consents. So it has to be done carefully. And again, lawyers, you need to discuss that with your lawyer. Okay, when you're making a power of attorney is I find it interesting that the courts are more worried about your stuff than they are about you. You have to seek legal advice to get a proper one done. If you want an enduring clause, which means a power of attorney document that's going to endure past your competency, in Manitoba, they can only be witnessed by lawyers, judges, or magistrates, a couple of other people. There needs to be an affidavit of execution attached in Manitoba. In other jurisdictions, they're not so strict about it. But the affidavit of execution states what class, whether or not you belong to one of those restricted classes, the judge, the magistrate, the lawyer. And it states that the person was competent when signing. So that's preventing challenges at court. Should somebody else come along and say, I don't believe that Mum was competent when she signed the power of attorney, giving Susan the attorneyship. The lawyer has covered that off in their affidavit of execution. There's one last thing about powers of attorney that, you can put any powers in. You can limit the powers. You can say they only have power to deal with my bank account. They only have power to deal with my investments. They don't have power to deal with my art collection. Whatever you want, you can make your power of attorney as broad or as narrow as you need it to be. If you're going to make a broad one, then just say to do everything the law entitles them to do. That's actually quite sufficient, but we've gotten into the habit of naming a lot of the powers. But one last thing that is not in the Power of Attorney document, and it's certainly not in our Power of Attorney Act, and it's not in our Personal Care Act either, is who makes decisions about placement, personal care placement for the individual. It's not really a health decision, it's a living decision. And it's not about your property. I recommend that it go into the Power of Attorney document rather than the healthcare document, because the attorney, I know the attorney had to receive advice and the document had to be properly witnessed when it was made by the lawyer who made it. I also think that it's the attorney who knows what the person can afford. And sometimes you can get a very well-meaning proxy placing Mom in a situation that she really can't afford, because that person may not know what the financial aspects are. So just a little word to the wise there. I recommend it go into the Power of Attorney. You should talk about that with your lawyer. Who's going to have permission to place me into personal care? Should it be my attorney? Should it be my proxy?
Before we get into the Comityship piece a little bit more, I'm wondering, Heather, can you help people understand about the need to take responsibility when you see a person who has granted you power of attorney responsibility to act so that a person does not become at risk financially, etc., because of inability to make good decisions. We know that everybody can make poor decisions at times, but isn't there a responsibility to assist a person to not put themselves at undue risk due to declining competency?
I get what you're after. Okay, so what we have is the donor, the person who's making the document, starting to slip in competency. That's what you're asking. And is there a duty on the attorney to step in? The answer is, according to law, no. However, if the attorney sees it, the attorney should be placing themselves close enough to the individual who is starting to lose competency and working side by side with them. This is a very tricky thing. I have noted clients who are quite willing to name powers of attorney, quite willing to have the attorney come into the office and discuss with me and the client, and then as competency begins to slip, not discuss anything with them at all. But I do believe that if you set it up early enough in a person's life, then they become attuned to having someone work with them. And I advise the attorney to work with that person as often as possible. And one of the ways we did get someone to start assisting an incompetent person who didn't want help was to say, I don't feel that I'll be able to act as your attorney unless I start working with you and see how you do things. And so the person gaily went about doing things continuing to do things, and attorney was there by their side and eventually began taking over more and more and more duties. But that was a success story. It is a problem. I have seen lots of cases where an attorney is out of town because your attorney doesn't have to live in the jurisdiction in which you live, and the attorney just won't act. If it gets to a severe point, then often a social worker will get involved, and they will either contact the attorney and tell the attorney to act, or they will get the public guardian involved. And that's just what sometimes happens. Okay, I'm going to go on to discuss what happens in Manitoba if you don't have a power of attorney. You really have 3 options if you are no longer competent and can't handle your own stuff. 1, you have an attorney. If you don't have an attorney, you only have 2 options left. There is something called a Comityship and the public guardian and trustee, either appointed or as comity. The comityship is private. It's made by a person who resides in Manitoba. It cannot be made by one of your children who lives in another jurisdiction. It has to be by somebody made in Manitoba. And I believe almost every court has, almost every jurisdiction has an alternate route if there is no power of attorney in place. They may not be called comityships, but they may be called something else. The point is they do have a legal route you can go. The problem is you have to make an application to the court. You have to reside in the jurisdiction in which the person you are applying to be comity over lives. So you can't make an application to be a comity for your aunt who lives in Nova Scotia. You have to live in Nova Scotia. The person has to have an interest or a connection with you. You can't just walk in. In the States, it's quite different. You just have to say, I know this person needs care, and here's a doctor's letter, and yada, yada, yada. Or you can actually bring the person to court, and you can make the application and be appointed their guardian without the court ever having seen a doctor's note. In Manitoba, you have to have affidavits from 2 different doctors, which means you get reports from 2 different doctors and make up an affidavit from their report, and the doctor then has to sign it. And you have to have some idea of the assets of the person. Now, every time I say the word court or application or affidavits or do any sort of, these are legal steps, you know it's going to cost you. And it's going to cost you more and more. To make a power of attorney in Manitoba, I know some people who do them for $150, and I know some who do them for $300. I don't know many who do them for much more than that, unless you want them extremely customized. But an application to the court for a comity application is $225 on the line first. When you're talking about hiring a lawyer to make that application, and you're talking about making affidavits, getting affidavits from 2 doctors, the doctors often charge for their time as well. So you're paying your lawyer's time, your doctor's time, the court, and it can sure add up. You also have to pay the public trustee, by the way. They have to be served. An application may be granted if all relations of equal or prior right to the applicant have consented. So if you are one of 6 children, all other 5 children have to give permission. If you are one of 19 nieces and nephews, the other 18 nieces and nephews have to give permission and consent. Then it gets a little messy. The public guardian and trustee has to approve as well. You have to serve them with all the documents and pay them, by the way, when you're serving the documents, just for reviewing the documents. You will have to file an accounting with the court within 60 or 90 days, whichever the court decides. And you will probably have to file an annual or biannual accounting with the court, just to make sure that everything is on the up and up. And by the way, when you file this accounting with the court, they want it to balance to the penny.
So what is the difference between the accounting filed within 60 and 90 days and the annual?
Well, the 60 to 90 days says exactly what they had on the day of the application. Okay? The annual accounting, you have to file within 60 or 90 days of the anniversary.
And so that's showing the action in the
that's happened in that year.
Establishment.
And believe me, they are strict. They are very strict. I tell my attorneys, don't use ATMs, don't use cash, do everything leaving a paper trail. It's fine if you want to do electronics, but make sure you keep photographs of everything you do, because the court's going to want to know, what was this $256 to High Steakhouse all about? They're going to want to know, because they do scrutinize it, and scrutinize carefully. So being a committee is actually no joy. It's a lot of work. It takes time to make the application. So during that time, the person's bills might not be paid. It's expensive. It can be 10 times more than a power of attorney. And in fact, I just ran into someone who applied for a comityship of an aunt, and the fees to make the application, because there was a child who was objecting, were over $18,000. $18,000. It would have cost this woman probably $150 to $200 to make a power of attorney, and because she didn't, it cost her estate $18,000. It can be subject challenge. You know, if you're one of 6 siblings, okay, we'll make you one of 3 siblings, and your sister-in-law doesn't like you much and wants her husband to be the committee, they can fight. And of course, any fight increases the expenses. There can be a lack of cooperation from the banks. They're not going to tell you anything ahead of time. They're not going to give you any information. They want to see the court order every time. It can be a real mess. The court scrutinizes everything, as I said, and there is no latitude, no margin for error. Now, if you don't do a good job as a committee, the public trustee can always step in. Or if no one comes forth to be the committee, the public guardian and trustee can step in. And the public guardian and trustee have an upside, believe it or not. Lots of lawyers don't think they do, but I happen to think they do. They are thorough. They know everything the person has. They're good stewards of your money, because they control so much money, millions and millions and probably billions of dollars for Manitobans in Manitoba, and I'm sure it's the same in other jurisdictions. They earn good interest on the money. They're not swayed by family politics. They don't care what Susan's husband said, or Mary said, or Bill said to Mary, or Mary said to Susan. They don't care. And they will cut you off. They just want to make sure that mom is safe and looked after. And you, the donor, or the person who should have been a donor, are their focus. So they do a good job that way. However, they can sell everything you own if they feel that it's draining your estate, or if they need the income from that asset to keep you going. I saw someone sell a cottage only because the taxes and the hydro and school taxes, municipal taxes, hydro, and water cost too much out of this person's income, and so they therefore were not paying the per diem rate, and so they sold the cottage, regardless of the fact that it specifically said in the will it was to go to one of the children. They charge fees for everything in and everything out. Whatever goes in has to come out at some point, whether it comes out while you're still alive or while after you're dead. They have no personal relationship with you. One of the saddest things I've seen was a person who was in personal care, public guardian and trustee were looking after them. Public guardian and trustee do not go into personal care homes and chat with their clients. They have social workers who do that. And the social worker will report to the public guardian and trustee. And nobody thought to mention to the social worker that this person had run out of nightgowns. And for ages, this person was wearing t-shirts to bed because nobody thought to tell the social worker, who never saw their client at night. They were wearing these threadbare garments. When finally, I actually mentioned to the nurse, there seems to be something wrong. The nurse mentioned it to the social worker, and the social worker applied to the public trustee and said, we need to buy new nightgowns. And then public trustee, guardian and trustee was very happy to approve and did. And the social worker then went out and bought the nightgowns. But it was sure a roundabout way. And there was no personal relationship with the individual that they were taking care of. Now we're down to the last document that everybody should have. You decide who gets what in your will. And only your spouse has a right to expect something. So don't let your kids try to tell you, we are your beneficiaries. You can't give it to anyone else. In some jurisdictions, in some countries, that's the way it goes. Sorry, folks. It goes to your family, and you can't override it. You can decide who will be in charge. In Canada, you can override. You don't have to leave money to your children, but you can't override who was named as executor unless they are incompetent or known to be bankrupt or known to have stolen money from this person. So, you get to pick. But you need to know only your spouse has the right to expect something. Excuse me. And your spouse, by the way, has to receive in Manitoba a minimum of 50% of your estate. So you can't say, I leave my spouse $1 and everything else to my kids. A will makes your wishes clear. It's especially important if you are you have a beneficiary who is under a disability or underage. It's the fastest and most efficient way of getting probate, and the executor is under court supervision. Now, this leads us to the question, what is probate? Probate is the process of proving a will. Now, what are proving? Probe and prove are the same root word. They're proving to the court this is the last will of the person. I'm the person, or the executor is the person who's supposed to be looking after it. You give an inventory of the assets that you're going to be looking after, and you promise to obey the law. That's what you're proving. Excuse me. A good will takes time to prepare. Don't expect to do it one interview over the phone, come in and sign. You should be sitting down with your lawyer, talking about your assets, what you have, how they're named, where they're going, what type of assets they are. You need to decide who you want to get what And what happens if that person predeceases you? Where's it going to go? You need to keep your will up to date. You need to know that, yes, you named your grandchildren, and your grandchildren actually are no longer in touch with you. You have no idea where they are. You need to know what to do, and your executor will need to know what to do. I had a very good friend whose son disappeared. Looked like he disappeared off the face of the earth, and was gone for 8 years. He did return. However, he was estranged from his family. And when we were doing her will, I said, what are we going to do about your son, Dave, who has disappeared? And we came to the conclusion that the executor should spend 1 year looking for Dave. Not to take extraordinary measures, but to contact people who might know where Dave is, or contact past employers, whatever. And if Dave had not surfaced within 1 year, then the executor was allowed to distribute the estate. So you can make those kinds of decisions if you have a frank discussion with your lawyer. If you're just answering questions on a form, or you're just talking to your lawyer on the phone and they then say, come on in and sign, you've got a problem. Go to another lawyer. The lawyer should go over your will paragraph by paragraph. Now, this is very important because we use a lot of legalese in wills. I try not to. I try to use plain English, but there's still a few things in there that aren't always obvious to you. Situation I had where there was a definition section on the will. Client asked me if his will was good, if his will was valid. I said, as far as I know. And then I had a conversation with this person and discovered that the 2 daughters that he was leaving everything to, if his wife predeceased him, were not his daughters by blood at all. And the definition section had said only blood relatives can receive under this will. So we had to make a new will, we had to go through all sorts of stuff, and he never knew it said that because it was a little bit jargon. And it's important you understand what that jargon means. So, as I said at the beginning, the executor has the right to make your funeral arrangements before probate, and your bank account can release money to pay for the funeral before probate. Your executor can charge fees. Now, if the executor charges fees, they're going to be taxed on it. Maybe you don't want your executor to be taxed on their fees. Maybe you just want to leave them a gift for being your executor. Then they don't have to pay fees on it, taxes on it. You might say, I leave my executor $10,000 just to be my executor. No fees will be charged, and you say in lieu of fees, then they don't charge fees and they don't pay taxes. A little better for both. Probate, I've talked about probate. Fees are very low in Manitoba. They're double. Manitoba fees are double in Ontario. I don't know what they are across Canada because these things do change. But in Manitoba, fees are $7 on each 1,000, which means you have a $1 million estate, it's going to cost you $7,000. Whoop-de-ding if you have $1 million. In Ontario, it would cost you $15,000. Now, it's a little more serious, but it's still not going to make a huge dent in 1 million. And I tell my clients it's far better to include things in probate if you're not sure than to worry about the fees. Some people try to use joint assets as a way of avoiding probate fees. But you put your house jointly into your child's name, I can think of to avoid probate fees, okay? That's what people would do. They would take a $300,000 house and put it joint in those names so that the $300 doesn't go into the estate. You put a joint name on that house? Does your child know that they're going to be liable for capital gains when you die? Capital gains are a heck of a lot more than probate fees, let me tell you. On a $300,000 house, they'd be paying capital gains on $150,000 because they paid nothing for the house. That's not very pretty. And they might not thank you for it. Not only that, if there's, supposing your son is on the house jointly with you, and your son's wife decides it's time to call an end to their marriage, she's entitled to half of his half. Oops, you didn't mean to do that either, did you? Nope. So I don't recommend joint names to avoid probate fees. Pay the probate fees. It's after you've gone. If you don't have a will, each province has what is called an intestate succession act, or an act that will cover situations where the person dies without a will. And someone can apply to the court to be the administrator of the estate, but you can only apply if you live in the province. So again, we wind up with the problem of you live in Alberta, your niece and nephew, who are your closest relatives, live in Ontario. They can't apply. Somebody else has to do it. It's time consuming, it's frustrating. Out of pocket expenses will take forever to be reimbursed, and it's going to cost you more in the long run. People ask me all the time about pre-printed will forms or power of attorney forms. Powers of attorney, if they have an enduring clause, have to be witnessed, as I said, by lawyers, magistrates, judges. So powers of attorney don't. You can't if you want it to be enduring. But a will form is something different because wills just require 2 witnesses. I don't recommend will forms. Now, a lot of my colleagues get a little annoyed when I give these lectures publicly and say, don't recommend will forms. They love will forms because I can tell you they make twice as much on an estate involving a pre-printed will form than they do on a will made by a lawyer. And the reason they do that is there are thousands of mistakes that can happen so easily. It can be much more expensive. I have only once in my entire practice seen a will form done properly, and that was by a legal assistant. The only time I've seen it done right. Other times, it's been a mess. And I wished I had let my client go ahead and do the will form. I would have made a whole lot more money. No, I'm just kidding. There's a lot of potential for abuse. There's conflicting instructions. Some of the gifts may fail because the wording is not done properly. It can be a real mess. So do I recommend it? No. I'd rather recommend you write it out by hand using simple language than using a will form. So, summation, be proactive, be prepared, get these documents while you can. Make decisions before you have to, and stay informed. If you have had a diagnosis of Alzheimer's in a spouse or a loved one, that may not preclude them making a will and power of attorney and healthcare directive, depending on the stage they are at. The test for a person being competent to make these documents is, do they understand the nature and effect of the document they are signing? Do they know what it is? Do they know what it does? Do they understand who should be expecting to be appointed? And in the case of a will, who are their next of kin? Do they understand who would be expecting to receive under a will? Do they understand the extent of their assets that this document is covering? And lastly, are they doing this of their own free will? That's what lawyers are trained to discern. And some lawyers might want the assistance of a doctor, just make sure, verify that they're correct, this person still has competency. And some lawyers might be just confident enough to say they were able to give me the answers to all the questions. When I'm teaching lawyers, I tell them document your file carefully, put down the questions that you asked, and what happens. But when I'm talking to the public, I say, make sure your lawyer goes over everything with you. And the lawyer who is interviewing you over the phone or takes instructions from a child of yours over the phone, or a niece or a nephew over the phone, and then has you come in and sign, isn't doing their job. You want another lawyer. Lawyers are available. We do charge money. But if you have good relationship with your lawyer ahead of time, we can save you a heck of a lot later. So thank you. That is my presentation. If you have any further questions, by all means, let me know.
Thank you, Heather. So if anyone has a question that they would like to enter into the question box that you see on your screen, go ahead at this moment, and I may have to recruit our host in Alberta to help me access that question, but we're going to give you a few minutes to do that. So Heather, one of the things I've often heard you describe, though, is how you work with a person who has dementia to work through that appointment so that that person is enabled, if they are, you perceive, competent to draw real power of attorney. Can you describe a little bit about how you do that in order to make it a successful appointment?
Well, I had one man come into my office once with his wife, and he said, my wife needs to make a will and a power of attorney and a healthcare directive. And I said, and you don't? And he said, no, I can't. I've been diagnosed with Alzheimer's. I thought it was interesting that he was speaking for the wife, but that's the way their relationship had gone. So what I do when I'm doing the review of assets, I do that in presence of both. When I'm taking the information, name, address, phone number, birth date, etc. But the actual signing of the wills and the creating of the wills is done separately. And when I spoke to the wife, she was far less certain about what she could and could not do than the husband. And the husband knew immediately what he wanted. I said, well, who would you have appointed? And he said, well, I would have appointed my oldest daughter, because she's the one that takes us to the bank, and she's the one who makes sure that we get places on time, and she's very trustworthy, and she's an accountant. And I thought, that's showing signs of competence to me. He understood that this is an important document, and he understood that he wanted someone who had ability and who he trusted to do it. And I said, what about your other children? He said, well, there's our son who doesn't seem to be able to keep a nickel in his pocket. I don't think he'd be very good. And he was able to describe his family for me so carefully that I thought, he obviously has competence in this area. Let's find out if he knows about his assets. Well, what he didn't know about his assets was so small I could have put it in a bucket and lost it. He understood his assets. He understood what the documents were going to be and be about. And when I actually prepared a document and put it before him, he said, "This paragraph here, I don't understand this." And I said, "Okay, this is a paragraph that's talking about the various banking methods your daughter can use." And he said, "I want her to be able to access all my accounts, my checking account, my savings account, and my TFSA account. That's a tax-free savings account, by the way." And I thought, he knows what he has. He understands what she's going to do. This man had competence to make a power of attorney. And same thing with the will. The wife, on the other hand, when she came in, she said, "I don't know much about our assets because I have nothing to do with them." Yet she was the competent one. There was no question. Of course, I made those. So people come in, it's a matter of listening and sometimes making them comfortable. One of the things I found is some people are better off early in the day, and some are better off before supper. So I have to be flexible and be ready to see the client when the client is ready. I will also see a client in their home if that is more relaxing for them, because sometimes people are fine in their homes. It's when they get outside their homes that the anxiety level rises and any difficulties with competency arise and are exacerbated. So you have to be careful, but you can do a lot of things, and you can really, really help people if you're doing the right thing. There have been times when I've had to say no, I can't do it. But I always offer the other person a chance to do a comityship or whatever. So it can go both ways, but listening, talking to the person. That's very important. Very important.
Okay. So is there any other question? We've answered the question about should a spouse be a power of attorney? And if there are any other questions, could we hear them now? Otherwise, Heather, we just really thank you for the time you've taken to come in this evening and provide insight for people. And we remind people that tonight is all about information, but decisions about exactly what they want need to be made with thoughtful consideration with a lawyer that they know. That the thing tonight is about helping to be able to ask better questions.
Know what questions to ask. Well, that's what I hope we've done. I feel very strongly that all adults should have these 3 documents, and not just when we're talking about people in their 50s and 60s and 70s, but they should be having these documents when they're in their 30s and 40s.
They're documents for living, not just for dying.
That's correct. But by the time you get to my age, you better have them in place.
That's right. Okay, so thank you so much.
You're most welcome.
And we want to remind individuals that view this webinar at a later time when it is archived, that if they have questions in general, they should talk to the Alzheimer's Society in their province, who would be able then to direct them on to legal counsel about the things that it's essential to talk to legal counsel about. The Alzheimer's Society will not provide legal counsel because that is not the work that we are empowered to do. What we want to do is help you to be an informed public, able to care for what matters most. Good evening, and thank you for being with us.
Thank you, and good night.